Hi there, Stephanie here from Michigan Alliance for Families. We are your guide to all things special education in Michigan. I am glad you have found us. You are here in our video library. Remember, we also have lots of information on our website, michiganallianceforfamilies.org, and our regional parent mentors are available to answer your specific questions. You can give them a call directly, 800-552-4821, for questions specific to your situation. But you're here at this video. Thanks for tuning in. We are going to spend some time defining what parent means in regards to special education, why that's important, and when it becomes relevant. So thanks for tuning in. Let's dive in. When you're looking for any information on special education, the best place to start is the Individuals with Disabilities Education Act. That is our federal law up that defines special education. It gives us all the details of what that looks like. States are going to add details of how we do that and what that looks like. We do that in our Michigan Administrative Rules for Special Education. IDEA applies everywhere. So when we're looking at the definition of parent, we want to start with IDEA. And IDEA defines parent as a biological or adoptive parent or a foster parent, unless a foster parent is prohibited by state law from serving as a parent, and that varies from state to state, or a guardian or someone appointed by a judge's order, or a person acting as a parent, or a surrogate parent who has been appointed by the school's local education agency. And I promise we're going to spend a lot of time there exploring what that means. One thing I do think is noteworthy that is not really in this section of IDEA is that when a student turns 18 in Michigan, all parental rights transfer to the student unless there is a legal guardian that's been appointed through court proceedings. So the student could act as the parent as well. We're going to dive into what all of these mean, and then we're going to spend quite a bit of time on surrogate parents today. In simple terms, biological parents share genes with their child through conception and birth. Adoptive parent has gone through the legal process of adoption. They're raising the child as their own. With a biological or adoptive parent, it is presumed that they are the parent in special education situations unless the biological or adoptive parent does not have the legal authority to make educational decisions for the child. So if a court has said that the biological or adoptive parent does not have legal authority to make educational decisions, that's when other people in the role of parent would come into play. If the court has not said they do not have the legal authority to make educational decisions, it is presumed the biological or adoptive parent is acting as the parent. A guardian is generally authorized to act as the child's parent or authorized to make those educational decisions for the child, but not the state if the child is the ward of a state. And we will dive more into that later, but that is important to know that if the state is the defined guardian, the state cannot make the special education decisions. It also is a little bit more complicated for our kids that are birth to 3. That is our Part C of IDEA. So if there is a judicial decree or a court order that identifies a specific person to act as the parent of the child or to make the educational or early intervention decisions on behalf of the child, then the person or persons must be determined to be the parent for the purpose of Part C of IDEA. But if that person identified by the court order is an early intervention service provider or works for a public agency, which could be your school district, which provides any services to the child or any family member of the child, then that early intervention service provider or public agency may not act as the parent for that child. So to simplify this, if your early intervention social worker is defined to make the educational decisions for the child, and the child receives social work from that provider, they cannot act as the parent for that child. And we'll talk a little bit in just a couple minutes about surrogate parents and when they would be assigned. This is one of those cases where that would come into play. The law also says someone acting as a parent, so an individual acting in place of the biological or adoptive parent. So thinking of grandparents, step parents, other relatives. If the child lives with their aunt and they are acting as the parent, they're the person that's legally responsible for the child's welfare. And now onto surrogate parents. We are going to spend a lot of time here just because there's a lot of information that I want to make sure makes sense about surrogate parents. So, according to our federal law, Individuals with Disabilities Education Act, IDEA, public agencies are responsible for appointing surrogate parents when they're needed. Public agency usually means school district. Your public agency is responsible for the identification and appointment of the surrogate parent. Um, Although it is the district's responsibility, your public agency's responsibility to provide a child's education, they may get assistance from your intermediate school district, an ISD, to identify and appoint a surrogate parent. While the ISD may assist, it is still the obligation of the district to appoint the surrogate parent, and the district has to include a plan or a method for determining whether a child needs a surrogate parent and assigning a surrogate parent to the child. Your public agency, again, your local school district or your local lead agency, which for early intervention is usually your intermediate school district, must ensure that the rights of the child are protected when a parent cannot be identified and they've already made reasonable efforts to locate the parent. They can't just say, oh no, we can't find the parent. They need to make reasonable efforts to locate the parent. Um, when the child is a ward of the state, I told you the state cannot act as parent. That's when we would look at a surrogate parent appointment. Um, Also, that detail where I told you that if the child is birth to 3, Part C, they can't be a provider or anyone employed. And then if the child is an unaccompanied homeless youth, as defined by the McKinney-Vento Homeless Assistance Act, and we'll look closer into the details of what all of these mean. When we're looking at qualifications for a surrogate parent, parents, they have to be at least 18 years old. They have to be willing to be trained to act as an educational representative. They have to be screened using the same procedures that the school district uses for school volunteers. So that may include like a criminal background check, that may include fingerprinting. It depends on the local school district. The public agency, local school district, has to ensure that a person selected as a surrogate parent is not an employee of the state educational agency, so that's Michigan Department of Education here in Michigan, or the local educational agency, that's your school district, or any other agency that's involved in the education or care of the child. So it can't be an employee of the district. It can't be an employee of the state that's connected to education and care of the child. That person has no personal or professional interest that conflicts with the interest of the child, and they have knowledge and skills to ensure adequate representation of the child. So there has to be some knowledge base, there has to be some training um, about the child's needs and how to represent the child's. When we are looking at what school districts do or how they try and locate surrogate parents, first preference is given to a relative, a friend, or a court-appointed advocate. That's the top choice when we're looking at who already knows the student, um, who's already looking out for their best interest. The Michigan Department of Health and Human Services may help identify a surrogate who already has a relationship with the child if they're involved in this process. Intermediate school districts, ISDs, and or local school districts, as defined by ISD plans, are expected to maintain a pool of possible surrogates who are already trained. So intermediate school districts have to have a parent advisory committee that's composed of parents of children with disabilities. Often members of the parent advisory committee are tapped to be in this pool where they are asked to volunteer for the pool of possible surrogate parents who are trained. Other community groups can also be contacted for the purpose of recruiting a surrogate parent, but those volunteers have to be willing to be trained to act as an educational representative. So we could think of like your PTA, we could think of your local ARC, we could think of faith-based organizations, Big Brothers Big Sisters, service clubs. Those community groups could be contacted when we're seeking out to fill that pool of possible surrogates, but they have to be willing to be trained to act as educational representatives. Surrogate parents get complicated in a couple of different situations. So, when we're looking at a residential placement situation, the district should conduct a careful review of documents and coordinate with any outside agencies that are involved with the education or care of the child to determine whether the parents retain legal authority to make educational decisions for the child or whether any other person has been appointed to make the educational decisions for the child. So it's important to note in these circumstances that a surrogate parent cannot be an employee of any agency involved in the care of the child. So remember, um, that's Michigan Department of Health and Human Services. Um, that's any child placing agency. That's any child caring institution employees and your local school district. So it cannot be, the surrogate parent cannot be employed by any agency involved in the education or care of the child. When the child is a ward of the state, and that means that they are a foster child, a ward of the state, or are in custody of the public child welfare agency, the surrogate parent may be appointed by a judge overseeing the child's case. When that is the case, the surrogate still needs to meet the requirements that we've already talked about for a surrogate parent. But it is something that there's all sorts of different forms of wardship of children, and that when we're figuring out what the legal status of the parent is or who's making the educational decisions, it needs to be made on an individual basis, and the public agency, school district, has to really carefully review any court orders to see if there has been a surrogate appointed before they appoint a surrogate when the child is a ward of the state. Surrogate parents are also assigned for unaccompanied homeless youth. Let's break this down a little bit when we're talking about homeless. This means a child or youth who shares the housing of other persons due to a loss of housing, economic hardship, or similar reason. They're living in a motel, hotel, trailer park, campground due to lack of alternative adequate accommodations, living in emergency or transitional shelters, abandoned in hospitals, live in cars, parks, public spaces, abandoned buildings, substandard housing, bus or train stations, or similar settings, are migratory children who otherwise fit the definition of homelessness, or have a primary nighttime residence that is public or private place not designed for ordinarily being used for regular sleeping accommodation for human beings. That's homeless. Then we need to add unaccompanied when we're thinking about surrogate parents. So the surrogate parent is assigned if someone meets the definition of homeless youth and is unaccompanied youth. Unaccompanied is that they meet that definition of homelessness and they are not in the physical custody of their parent or guardian. So, when a child meets the definition of homelessness and is not in the physical custody of a parent or guardian, a surrogate parent will be assigned by the district. I told you that when students turn 18 in Michigan, they have all the rights of a parent. So, for children who reach the age of majority, that is what it is called in Michigan, it's age 18. They make their own educational decisions unless a legal guardian has been appointed by the court to make the educational decisions, or the student has granted another person a power of attorney to make educational decisions. So when the student is 18, all parental rights transfer to the student unless a legal guardian has been appointed. And a guardian, again, is a person appointed by the court and given power and responsibility to make certain decisions about the care of another individual. And that when we're talking about guardianship, the judge should be tailoring each guardianship to meet the needs of that one individual. All right, so those are all the definitions of who's acting in the role of a parent or who has the rights of a parent, basically. And the reason why that's so important is that IDEA, Federal Law, Individuals with Disabilities Education Act, defines parental rights, and these are where you find protections for the family and the student. So parents have the right to receive a complete explanation of all procedural safeguards available under IDEA and the procedures in the state to protect their rights also. They have the right to confidentiality, and they have the right to inspect and review educational records of their child. They could ask to amend or change an educational record. Parents have the right to participate in meetings that are related to identification, evaluation, and placement of their child, and also the provision of FAPE, a free, appropriate public education that's offered every year in the individualized education program to their child. So, parent is participating in the meeting related to identification for special education and related services, evaluations, placement, and free appropriate public education. Parents have the right to obtain an independent educational evaluation of their child. Um, they disagree with an evaluation that the district has completed. The person who has the role of parent and the rights of parents can request an IEE, an independent educational evaluation. The person in the role of parent has the right to receive prior written notice on matters related to identification, evaluation, placement, and the provision of FAPE for their child. They have the right to give or deny informed consent before the school can take certain actions with respect to the child. And parents have the right to disagree with decisions made by the school system on any of these issues. The rights of parents are important for IDEA. This is how we resolve disputes. This includes the right to appeal determinations, that these rights and who holds them are essential for our students receiving the special education supports and services that they need to meet their unique needs. I hope this information was helpful on who can act as a parent, when those protections kick in, and what parental protections are. Remember, if you have questions specific about your situation, reach out directly to your regional parent mentor, 800-552-4821. For general information about special education, follow us on social media. We're active on Facebook, Instagram, and you found this video on the YouTube channel. Feel free to check out other videos here as well. And thank you for tuning in. Michigan Alliance for Families is an IDEA grant-funded initiative of the Michigan Department of Education, Office of Special Education, the Michigan Department of Lifelong Education Advancement and Potential, and Michigan's Federal Parent Training and Information Center, funded by the U.S. Department of Education, Office of Special Education Programs. Have a great day.